Welcome to the deep dive. If you've ever kind of pushed estate planning to the back burner because, well, the whole idea of lawyers, paperwork, courts, it just seems like too much. You're definitely not alone there. Legacy planning is really important, but yeah, the complexity can feel overwhelming. So, our mission today, using the sources we've got, is to really cut through all that noise. We're going to dive into the specifics of like efficient estate planning specifically for California families, and we're focusing on a model that the sources talk about as being simple, secure, and completely yours. It's called the Golden State Living Trust Plan. Okay, let's unpack this. We're basically looking at how a pretty sophisticated legal setup gets combined with modern tech to smooth out those bumps in the road, the stuff that usually stops people.
That's exactly it. We're analyzing the facts here. Why is this one specific tool, the revocable trust, or living trust as it's often called, so vital for anyone with assets here in California? And, how does this particular plan, the Golden State Living Trust Plan, address that feeling of being swamped with information and, frankly, the high cost of just not doing anything?
Right. Okay, so let's start with the pain point, probate.
Yeah, the unavoidable reality. If you don't have the right estate plan set up, your estate gets pulled into mandatory probate. That means court supervision, delays, public records, and fees and potential taxes that honestly could have been completely avoided.
And the sheer scale of these fees in California, it's kind of shocking when you see the numbers from the sources. These are statutory fees set by law. So let's put some figures on it. Say you have an estate worth $500,000. The sources show the combined fees for the attorney and the executor can hit around $26,000.
$26,000 gone right off the top.
Just like that, diverted from who you actually wanted to leave that money to.
And it's crucial to get how that's calculated. It's not based on the net value, like after you pay off debts or mortgages. No, California probate fees use the gross value. So if you own, say, $1 million home, but you still owe $700,000 on the mortgage, the fees are still calculated based on that full $1 million.
Wow. Okay. So for a typical California homeowner, maybe with an estate around $1 million, which is pretty common here, those combined statutory fees jump up to about $46,000.
$46,000, that's a guaranteed loss your family takes if you go through probate. Money that should have stayed with them.
A loss that proper planning avoids.
Exactly. And that's why the living trust structure is so key. When your assets are properly titled, put into the name of the living trust, well, they're technically owned by the trust, not you personally anymore. So when you pass away, those assets just bypass probate completely. They go straight to the person you named as successor trustee to distribute according to your instructions. Now, you still have final income taxes, obviously, but the right estate plan, like this revocable trust-centered plan, can really cut down or even eliminate estate taxes if those apply to you.
So who is this really aimed at? The sources define the audience pretty clearly. It's people, families, small business owners, typically with small to medium estates, generally defined as being worth $10 million or less, which, let's be honest, covers the vast majority of Californians who need protection from that fee structure we just talked about.
Exactly.
Okay, so that's the problem. Expensive, slow, public probate. Let's shift to the specific solution highlighted in the sources. The Golden State Living Trust Plan offered by Mitch Jackson and his team.
Right. This specific plan is built entirely around the revocable living trust. You should think of the living trust as more than just a document. It's like the central command center for your assets. It's really the backbone of a smart, secure plan. It's the one thing that holds everything else together to make sure assets transfer smoothly, privately, and efficiently.
And here's where it gets really interesting, looking at their approach. It's not just old school lawyering. They've built what the sources call a digital-first planning studio. But, for our listener who's thinking about precision and legal soundness, if it's mostly digital for convenience, how do they ensure the rigor? What about the potential downsides of speed versus, say, traditional face-to-face legal advice?
That's a really important question. The key is making sure the plan is absolutely customized for California law and, the unique situation of each family. And that's where they blend the tech with the attorney expertise. The convenience part is mostly in the data gathering, not the actual legal drafting or advice.
Okay, so how does that work?
Well, the sources explain they use AI for process automation. Things like collecting your information through secure online questionnaires, organizing complex lists of assets, doing it quickly and accurately. This cuts down massively on the time an attorney might traditionally spend just on data entry, the administrative stuff.
Right, the billable hours sink.
Exactly. So the attorney, in this case Mitch Jackson, can then focus their time on the high-value work, the customized legal counsel, making sure the structure is right for you, and drafting the final legally sound documents.
Got it. So AI handles the admin lift, the attorney handles the crucial legal customization and makes sure it's all compliant. And that partnership lets them offer the whole thing remotely, like from your couch using phone or Zoom.
But that's the idea. Cut out the driving, the office visits, the wasted time,
Mm-hmm.
but you still have that essential attorney backing and direct consultation. The goal is confidence, not confusion.
Makes sense. Okay, let's dive deeper into the benefits of this core component, the revocable living trust itself. The sources seem to group these benefits into a few key themes.
Yeah, they really boil down to three main areas: financial efficiency, control, and incapacity planning, and family protection and privacy.
All right, starting with financial inefficiency. We've already hit the big one. Saving your loved ones from that huge cost and time drain of California probate. But there's another angle too, right? What if you own property outside California?
Good point. A properly set up living trust prevents needing multiple probate processes. If you own a vacation home in Arizona, or maybe property back east, without a trust, your family might face separate probates in each state. A trust consolidates that, avoiding a massive logistical and financial headache.
Okay, and just practically speaking for the person handling things after you're gone.
It just makes administering the estate much simpler, faster, and honestly way less stressful for your successor trustee. And that speed often means beneficiaries, especially in those small to medium estates, can receive their inheritance faster than if it was all tied up in court.
Okay, second theme, control and incapacity. This is interesting because it's a benefit you might experience while you're still alive.
Absolutely. This provides peace of mind now. If you were to become incapacitated, maybe through an accident or illness, unable to manage your own affairs, the living trust prevents a court needing to step in. You avoid a conservatorship proceeding where a judge appoints someone to control your assets. That's public, expensive, and potentially stressful.
So
Instead, the successor trustee you already chose when you set up the trust takes over management, immediately, seamlessly, following the instructions you already laid out.
yeah.
So you stay in control of your assets while you're alive and well, and that control structure stays perfectly in place after you pass, dictating exactly how and when things are distributed.
Grid's flexible.
Totally, because it's a revocable trust. That means you can change it, you can amend it, you can even cancel it entirely anytime your life circumstances change. Marriage, divorce, kids, grandkids, you name it.
Right. Okay, the third theme, family protection and privacy. This feels really important today.
It is. Probate is a public record. Anybody can walk into the courthouse or often look online and see a full inventory of your assets, your debts, who inherited what. It's all out there. A living trust keeps all of that completely private. Your family's financial affairs remain confidential.
And beyond just privacy, what about protecting the next generation?
Well, the living trust structure offers some powerful tools there. For instance, it stops the court from getting involved in managing inheritances for minor children. You decide within the trust when they're old enough to handle the money responsibly. You can specify assets stay in the trust, managed by your trustee, until the beneficiaries reach, say, age 25 or 30 or whatever age you choose. It's customized protection.
Might make sense. You tailor it to your kid's maturity.
Exactly.
Okay.
And that customization goes further. The sources mention you can structure the trust to protect family members with special needs. You can ensure their inheritance doesn't disqualify them from vital government assistance programs they rely on.
That's huge.
It really is. Plus, the documents note that a living trust is generally much harder for someone, maybe an unhappy relative, to successfully challenge compared to just a simple will.
More legally robust.
Yes. And it can even be a useful tool if you're getting married, especially later in life, and want to clearly define what's separate property versus community property, setting clear financial boundaries.
Okay, so a lot of layers of protection there. Let's talk process. For someone listening who's thinking, okay, this sounds like what I need, how do they actually start the Golden State Living Trust plan? How does that convenience and rigor play out in practice?
It's designed to be straightforward. The sources outline a simple three-step process, keeping that digital-first approach, but with attorney oversight. Step 1. You reach out to Mitch Jackson's firm. They send you a link to a confidential online questionnaire. This is designed to gather all the necessary info efficiently.
Okay, like names, assets, beneficiaries, that kind of thing.
Exactly, all the foundational data. Step 2. You complete that questionnaire on your own time. Once it's done, you schedule a review directly with attorney Mitch Jackson, usually by phone or Zoom. This is key. This is the consultation part. You get to ask all your questions, make sure you understand everything, get comfortable, and the sources are clear. You only make the payment after this consultation, once you're satisfied and ready to move forward.
So you talk to the actual attorney before committing financially.
Correct. Then, step 3, assuming you proceed, the firm drafts your complete, customized estate plan. The trust, wills, powers of attorney, everything. They send it to you for a final review, along with clear instructions for signing and notarizing.
Okay, that sounds clear. But the timeline claim that the whole plan is normally done within 7 days, I have to admit, that sounds fast for legal work, especially if it's truly customized. How do they manage that without rushing the important stuff?
Yeah, that's a fair pushback. The speed, according to the sources, comes from the efficiency gained before the attorney starts drafting. It's about eliminating the traditional delays. Because that digital questionnaire gathers and organizes maybe 90% of the raw data needed, and it's likely error-checked by the system, the attorney isn't bogged down in basic info gathering. They can jump straight into the high-value legal work, structuring the plan correctly for California law, customizing it for your specific family and assets, and producing the final documents. So the focus is on efficient execution, not rushed advice.
So the system streamlines the prep, freeing up the attorney for the critical legal thinking and drafting. Makes sense. And the goal then is a plan that's affordable to set up compared to maybe traditional hourly billing, and also simple to maintain over time, which tackles that initial fear of complexity we talked about.
Precisely. It addresses the core anxieties around cost, time, and complexity.
Okay, let's wrap this up, tying it all together.
Sure. Looking at the big picture, it seems clear from the sources that a customized living trust structure, like the one offered in the Golden State Living Trust Plan, is really the most effective defense against California's probate system. It gives you control now, ensures privacy later, offers potential tax advantages, and crucially helps your legacy avoid those significant, unnecessary probate costs and delays. It's fundamentally about providing, well, real peace of mind.
And when you circle back to those statutory probate fees we discussed earlier, potentially tens of thousands of dollars just gone, it really frames the question, doesn't it? What is the true cost of inaction? The issue isn't really if you need an estate plan in California. It's more about how quickly you can get a solid structure in place to protect your family's future. And on that note, the sources emphasize that Mitch Jackson and his team really do enjoy answering questions. So if you're listening and you have questions about any of this, definitely reach out to them, phone, email, their website. They want to help clarify things. Even better, if you feel ready to get started with your own Golden State Living Trust plan, the message is clear. Give Mitch a call. The sources suggest that by this time next week, potentially your estate plan could be done and your family protected.